that as a voter in this region and as a person who expects service delivery from both the governor and the representatives of the people in the name of MCS. I will address three issues that my learned friend has touched on, just to clarify. Then I will go straight to my closing remarks because I think most of the issues have been responded to in a substantive manner. One is on the much hyped China trip, where the governor is being accused of sending her relatives, and in the process funds belonging to the public were lost or misappropriated. Mr. Speaker, sir, your own document that has been tabled in this House by the mover of this motion is a letter dated 25th April 2023. That is the letter that was inviting the governor to the China trip. It was not an invitation for a technical committee. Let us be very clear on that, Mr. Speaker, sir. This is a letter that was inviting the governor to benchmark. This is a letter that was inviting the governor from a private company for her to be able to visit China and form an opinion as to whether there is need for her to borrow a few good practices from there and import them to Meru. There is no indication in that letter that indeed she should be joined by a technical committee. If you may allow me read, Mr. Speaker, sir, paragraph 1 says, "We are delighted to invite you and your distinguished members to visit us in China for you to witness and benchmark our state-of-the-art linear accelerator machines designed and manufactured in China in reference to our planned cancer treatment center in Meru." Mr. Speaker, sir, the mover of this motion should have indicated what was the essence of this visit. If governor chose to go to this visit alone, it would have still be within her rights. There was no requirement for her to go with any technical committee. It was not a study, a trip. It was an invitation for the governor to go and witness what is happening there and come back and commence the process of having a similar project in Meru. Secondly, Mr. Speaker, sir, the second last paragraph of that letter is very clear on who was footing the bill in this trip, and says, "You are expected to visit us in late May and June for a minimum of 1 week. We will cover all your expenses, that of your entire delegation in China, including travel, hotels, and meals." So how then can we fault the governor for using public funds in a trip that was privately funded by a private company in China that wanted to come and invest in Meru? Surely, honorable members, we are not being fair. This cannot be a ground to impeach a governor accusing her of misappropriating funds when there were no funds allocated or even utilized in this trip. On the other issue, my learned friend has told you about the naming of one road after the first gentleman. For clarity purposes, my learned friend Mr. Omari has not admitted, and I want that to go on record, that indeed there was a road named under or in the name of the first gentleman. What he's saying is the governor in her wisdom is allowed to do certain acts, but in this case we deny that there was any naming of a road. I was expecting the mover of this motion to table evidence before this court that are in tandem with our statutes on how a road has been named. When I walk along the Meru streets, Nairobi streets, and any other street, there are clear signages that indicate Jorincheke Street, Moi Avenue, Tomboya Street. I invite the mover of this motion to show me one signage that reads Muregabaichu Road. None. So how is it that we are talking about naming a road that has not even been named at all? Where is that signage? Where is that instrument in the hand and seal of the governor naming that road? So that then we are able to accuse her of breaching the law. A Facebook extract is what was produced. The governor states that was just a humorous comment on social media. Does that constitute an executive order? Does that constitute a government directive? It does not. So we cannot then rely on social media extracts and then accuse the governor of having done or not done a specific act. Let that be clear. And I was expecting the mover of the motion to be able to do that. The other issue that I want to address before I go to my closing remarks is the issue of contempt of assembly. And allow me state this. This particular count does not exist under our statutes. I was expecting the mover of the motion to show us which particular standing order, which particular statute, which particular provision of the Constitution the governor breached by failing to appear before the House Committee. And at what point does failure to appear before a House Committee amount to contempt of assembly? My understanding is that the governor was invited. She responded through a letter requesting for interpretation and proper application of Article 175 and 195, whether the Speaker can indeed summon a sitting governor. There was no response from the Speaker giving directions on whether it was provided for under the law that the governor could appear before the House Committee to answer to charges. In a proper setup, when there is a response to a summon, the person then who initiated the summons is expected to respond to that particular complaint or concern that has been raised. Yes.
Please allow me to inform you that the first letter that summoned the governor was signed by the Speaker, and nobody else has the powers to write a letter to the governor except the Speaker. In the first instance, the letter that I received from the governor stated very clearly that the governor was attending a meeting convened by His Excellency the Deputy President. A reminder that I wrote again the second letter requesting the governor to appear to the committee. She said that she cannot appear to the committee. So generally, she gave two contradicting letters. And I believe by the time she wrote the first letter, then she must have consulted the lawyer. So please bear with us on that. It is clear, the way she wrote the letters, she knew that she's supposed to appear before the House Committee.
Thank you very much, Mr. Speaker, sir. In my usual duties, when the court summons, you fail to appear, what they do is to issue a warrant of arrest. If you then respond to summons, giving an explanation as to why you cannot appear, then there is a determination on that issue. Mr. Speaker, sir, what then we expected is that once the governor raised the issue of interpretation and application of Article 175 and 195, the Speaker ought to have informed the governor that indeed the opinion of the House and the Speaker is that they have the powers to summon. Only then would the governor be in a position to seek further advice and make a decision on whether to appear or not. In any case, Mr. Speaker, sir, let us interrogate the contempt of assembly count, assuming that indeed the county assembly had the powers to invite the governor before it. How did this form the basis of the impeachment motion? The impeachment motion itself is dated 16th of October 2023. All the members in support of that motion signed the motion of impeachment on or before the 16th of October 2023. The records will bear me witness. The count that forms the basis for contempt of assembly is based on the report by the JLAC committee. That report was not tabled, debated, and adopted by the House until the 17th of October 2023. Indeed, the mover of the impeachment motion first tabled the impeachment motion, then thereafter the JLAC report was tabled, discussed, and adopted. How then did a motion that had not been tabled before the House form the basis of impeachment in a motion that had been prepared a day before tabling? Mr. Speaker, sir, my humble submission is that this is not a count that ought to have found itself in the impeachment motion. On that basis, it is defective. Having said that, I will go straight to my closing remarks so that the House can proceed to its next business. And I'll begin by just asking a question. Why are we here today? The members of the County Assembly, elected and nominated, council representing the governor, the Honorable Speaker, why are we here today? Now, the County Assembly, and I do not wish to lecture you on your mandate, you have three main roles. One is legislative, second is oversight, and the third one is representation. You are seated here today representing 45 wards of this great county. Therefore, whatever you say, whatever position you take must be that which has been given to you by your people. So as you sit here, ask yourself, am I speaking for and on behalf of the people who elected me? Or am I speaking on behalf of other voices? If you're not speaking for your people, then you have failed in your representation mandate. That is a question that I will leave for your conscience and interrogation. Of course, we are not here for any legislative business because we are not passing any laws. So I'll not talk about your legislative role. I will go straight to the other role, which is oversight. Oversight is a daily, it's a routine duty of a member of County Assembly. And today is one of those rare moments when a County Assembly exercises the harshest form of oversight. That is, discuss the impeachment of a sitting governor who has been elected in the same manner as you. Now, are we here to impeach the governor? Are we here to impeach the governor? I am glad that you've said that, because it means you failed in your role. You are not here to impeach the governor. You are here to interrogate whether the governor is guilty or not. So if you came here with a formed opinion that you are impeaching the governor, and I'm glad you say, yes, you are here to impeach the governor, then how are you expected to interrogate issues fairly and render a just determination when you've already formed your mind that we are here to impeach the governor? It simply means that we have gone out of our oversight role and taken a stand when we are supposed to be a quasi-judicial body interrogating facts. My reading of section 33 and 181 of the Constitution says that you shall look at the grounds for impeachment, that you shall interrogate the facts, that you shall give the governor a chance to be heard. Only then will you form an opinion whether you're going to impeach or not. So can we surely say that we came here with an impartial mind, sitting as an impartial court or quasi-judicial body? Are we ready to listen to the facts, interrogate them objectively? But your answer was that we came here to impeach the governor, which is not what you're here to do. You're here to interrogate, then render a judgment. Just to demonstrate that fact, and perhaps that will be my last bit. So then, what are you expected to do? You cannot take a stand as a house. The only person who is supposed to take a stand in this motion is the mover of the motion. Because him, it is expected. He has interrogated the issues and he is deemed to be the accuser. You're seated as a court. You have seen nothing, you have heard nothing, until the mover of the motion talks about the allegations. Then you compare those allegations against the defense put forward by the governor, and then, just like a judge, render your decision. At some point, you and I will face the judicial system in this country, either as a complainant or as a defendant. When you do that, I want you just to close your eyes for a moment and imagine appearing before a judge who has already made statements pronouncing your guilt. The first application you do is for that judge to recuse himself from the matter. When I hear what you're saying, honorable members, it is an indication that you have gone out of your way, joined the mover of the motion, and that whatever we are doing here is an exercise in futility. Because you are not capable of looking at the matters objectively.
Counsel,
You've already taken a stand.
Mutuma,
Yes.
you have 30 minutes, but please be mindful of the language that you are using. You cannot tell the honorable members that what they are doing is work in futility. It's not right. These are honorable members. Please address them with decorum. Please, I gave you 2 hours with a lot of respect. Please respect the honorable members. And this is an honorable house. You are aware, you understand that what I mean.
Thank you. Thank
Please
you, Mr. Speaker,
continue.
sir. Perhaps I can rephrase and try to be a bit lenient with my language. The governor's feeling and position and perception is that a decision has already been made outside this walls of this assembly. So that a decision to impeach her was formed elsewhere and then transported into this house. I am merely communicating the sentiments of my client. You will forgive me for just being loyal to my client. Now, then, for you to be an impartial court, quasi judicial body, what do you need to do? Number one, you need not to have a stake in the proceedings. You cannot be seen to have interest in the proceedings. The moment you have interests that conflict with your impartial role, then you're not capable of rendering a just and impartial decision. As I move on to the next point, is that I expected members of this honorable house to put Honorable Kawira to task, to question him on the allegations, for him to produce witnesses before you, for you to be able to look at the issues and the allegations fairly.
Counsel Mutuma, in this case, Honorable Kawira is not the subject, because I see it in our document, a list of 64 members who signed. So these members signed. I don't think they signed a document that they not read. They must have read and then signed. So now how are you saying that they put the majority leader of the mover into task? Please, let's move on.
Thank you. Thank you. Perhaps you'll allow me to substantiate that thought a bit. Is that I took a lot of time to explain the composition of this house and the purpose that brings this house to sit in the manner it is. It is a quasi-judicial body. Quasi-judicial body means that you're sitting to hear charges, that you're sitting to hear the complaint from the complainant, that you do not take the face value of the issues. And that's why I said it would have been expected that the person who accuses, and in this instance is the mover of the motion, should be put to task to provide evidence In law, we call that the burden of proof. I have not heard from the members, or perhaps maybe I'll hear, maybe it's too early for me to make that determination, members of the county assembly demanding the mover of this motion to discharge his burden of proof, so that it is clear in our mind that we are sitting here as a quasi-judicial body. And the reason why, Honorable Speaker,
Honorable Council, I gave you the opportunity after the mover moved the motion to also make a response. The next stage that we are going to is I'm going to allow the members to make their contributions. And then lastly, I'll give you another opportunity for you also to make your comments after the members have contributed. And then also lastly, I'll give the mover an opportunity to respond, then we move on. So probably you can reserve those remarks now for later hours.
Most obliged.
Thank you, can continue.
Mr. Speaker, sir. So lastly, in the reason why Her Excellency the Governor of Meru, who appears before you as an accused person, feels that a decision to impeach her is not based on any merit, is not based on any facts, is, among other things, our observation of the conduct of the members of this House, outside this House. Allow me say this, because if I do not say this, I will not have discharged my duty as an advocate sent by my client. On 14th of October 2023 rather, a number of the members of this House were spotted, and it is captured on both print and electronic media, taking an oath to impeach the governor before the Njorincheke Council of Elders. That was on 14th of October. Ladies and gentlemen, this motion was brought to the House on 16th of October. So these members, Mr. Speaker, sir, were influenced at the expense of their lives and their families to take a stand on whether they are going to impeach a governor or not. Sadly, Mr. Speaker, sir, the Speaker was in that meeting. Sadly, Mr. Speaker, sir, the move of this motion was in that meeting. Sadly, Mr. Speaker, sir, one Mwenda Ali was in that meeting.
Council Mutuma, I'm a senior member. Please resume your seat. You don't stand when the chair is talking. I'm a senior elder of Njorincheke and the former Deputy Secretary Njorincheke for 7 years. So there is nothing that can be done in the shrine. I must be there, not unless I'm out of the country. Please take note of that. And I believe also the members here are members of Njorincheke. So please, by the virtue of being there, they are members of the group. You can continue.
Thank you for that guidance and clarification, Mr. Speaker, sir, because then it confirms my allegation that indeed a number of MCAs in this sitting were present. What then I am concerned about on behalf of my client, and which my client has asked me to raise before this House, is the oathing ceremony, where she witnessed members of this House confirming that they will be part and parcel of the impeachment, and the person administering the oath giving even a warning that should you then backslide from this oath, you're putting your family at risk. Is that the motivation that brings us to this House today, to impeach the governor? If that is the case, then it is a sad story. Thank you, Mr. Speaker, sir.
Thank you, Council Mutuma. Yes, Mwenda, you can continue, but I believe you have like how many minutes?